The following is a presentation of Muddy River News.
Mr. Johnson appears in custody and with counsel. Mr. Todd Nelson, people appear. Johnson, there's been a 4-count amended information 2023. You committed the offense of conspiracy, armed robbery, in that you, with the intent that the offense of armed robbery in violation of Illinois law be committed, agreed with Fallon Gillum, DeMarco P. Smith, JVM, DRS, MJS, KJJ, MRW, and ZMS to the commission of that offense and performed an act in furtherance of that agreement, all in violation of Illinois law. That, as alleged, is a Class 1 felony. The 11th day of October 2023, you committed the offense of conspiracy robbery in that you, with the intent that the offense of robbery in violation of Illinois law be committed, agreed with possible penalties for a Class 3 felony. Would be a sentence to the Department of Corrections of 2 to 5 years and or a fine of $75 up to $25,000. About the 11th day of October 2023, you committed the offense of attempt robbery or denial of pretrial release. Along with that, the people have also filed several certified reports.
We're asking the reports may be part of the record, and the court be allowed to consider those. Also, Your Honor, I handed the court today an amended petition for denial of pretrial release. Because we filed that amended information. The detainable offenses would be the attempts, not the conspiracies, because the legislature did not see fit to include conspiracy when they drafted these laws.
All right. So the people's amended petition then are only to detain because of the attempt charge. 3 and 4, yes. Are 3 and 4, and then reports, and the people are asking the court consider those for evidentiary purposes for today's hearing. Is that correct?
Available. We sent that message to the defense that they were available for viewing should they choose to do so. So available to them for today's purposes.
And for today's purposes on the denial
evidence today.
Okay, then argument, Mr. Jones.
Thank you, Your Honor. This defendant is a risk of harm to the community. And I think based on the totality of the circumstances, the court should make that finding and make the finding that this defendant, for the protection of the public, needs to be detained until the trial can be held. The first factor the court should and can consider is the nature and circumstances of the offense charged. And Your Honor, the court had a chance to review those police reports, and I know that there were lots of them. But in brief summary, Your Honor, this defendant, along with many other defendants, some of which were juveniles, some of which were adults, actively engaged and conspired and agreed, and not just agreed to commit the offense of armed robbery and robbery, but took a substantial step towards the completion of that offense, and that this defendant and multiple other co-defendants went into a house with the intent to rob and commit an armed robbery. And we say armed robbery because in the myriad of text messages and Snapchat messages that we have, and that this court has had a chance to review between not just this defendant, but multiple other individuals charged and uncharged, they talk about pistol whipping the boys that were in the house. These are the facts of the case that the court has to consider in making this determination. The court also should and can consider the fact that as a result of this defendant's actions and the other co-defendants, a 16-year-old girl was shot and killed. As a result of what this defendant did, a 16-year-old girl is dead. He did not pull the trigger, admittedly. But under Illinois law 3 years ago, we would have charged this defendant along with every other co-defendant with first-degree murder. And the legislature changed the law over the objection of multiple state's attorney's offices. Because we said that this is what's going to happen. There's going to be a situation like this where a 16-year-old girl is going to be dead, and we're not going to be able to hold people legally responsible for their moral culpability. That's where we are right now, Your Honor, because the legislature did this, and the legislature isn't the one who has to sit down with the families and
Your Honor,
explain that.
I'm going to object. I think this is going beyond the scope of the purposes of today's argument.
The court will note the objection, but will overrule the objection as argument. The court can determine what is relevant and what's not relevant to today's purposes. So, Mr. Jones, you may proceed.
The legislature isn't the one that has to sit down with the families and say, we can't charge first-degree murder now because of what they did. Our office is the one that has to have that conversation with them. Our office is the office that has to have the conversation to explain to them why we can't charge this defendant with first-degree murder. The court can consider that in determining the nature and circumstances of the case and whether or not detention is relevant. The court can consider the fact that in those text messages, this defendant, along with the other co-defendants, talk about pistol whipping someone, indicating that they had access to a firearm, a pistol. That's a factor the court can consider in determining whether or not detention is necessary. The court can consider the age and physical characteristics of the defendant. The court can consider all those factors. And it's not an either-or. It's not a weight of the evidence. It's not that there are one or two factors that indicate that detention is necessary and that the other factors might not indicate that detention is necessary. It's the court's determination based on the nature and character of the offense and the factors surrounding those things. The court is to determine whether or not detention is necessary for the protection of the public because this defendant poses a risk to the public. And this defendant clearly does. And also, Your Honor, finally, the nature and character of the offense. This was an armed robbery where they were trying to steal a gun, where they're trying to take a gun from someone else. That's something the court can consider in determining whether or not this defendant is a risk to the public. He was trying to steal a gun. Your Honor, the balance of the argument is clear, that it's clear and convincing that this defendant should be detained until the trial takes place. Thank you, Your Honor.
Thank you, Mr. Jones. Mr. Johnson, you wish to be heard.
Your Honor, the first factor the court should take into consideration is the nature and circumstances of any offense charged. Offense charged. The state believes that this should be a murder case. And because the legislature has acted as they have, the state is upset with that and essentially wants this to be a murder case, but has spent probably half of today's argument talking about why this should be a murder case. The statute says offense charged. So what we're dealing with are the charges of attempt armed robbery and attempt robbery. There was some reference in the discovery to quote pistol whipping. I didn't see numerous references throughout that. The reference that I saw was made by one particular individual. The court should also take into consideration evidence of defendant's prior criminal history and whether that indicates violence or abusive or assaultive behavior. When we look at Mr. Johnson's prior criminal history, there is none. There are ordinance violations. 4 of them, to be exact. And the court should take into consideration any evidence of defendant's psychological, psychiatric, or other similar social history which tends to indicate a violent, abusive, or assaultive nature. There's no evidence of that whatsoever. Your Honor, Mr. Johnson has been employed. He was employed until he was arrested in this case. He lives in Adams County. He's young. He's 23 years old. We would ask that the court find that the state has not proven today what they need to prove by clear and convincing evidence that Mr. Johnson should be detained.
Thank you, Mr. Nelson.
A 16-year-old girl was shot in the head and killed. That's the circumstances of the offense charge. That as a result of this attempt armed robbery, a 16-year-old girl was dead. Now, I can't charge first-degree murder, and the counsel was right. I am upset about that. But I'm allowed to talk about the circumstances of the offense charge and what happened in those circumstances. And the circumstances are just that. But for the fact that the legislature changed the law 3 years ago, I would have charged first-degree murder. And that's a circumstance that the court can consider as well. So I think based on the nature and circumstances of the offense, the factors that go into that, the court should find by clear and convincing evidence that this defendant should be detained.
First of all, the court would note that there was a pretrial services bond report. Well, it used to be a bond report, now it's a pretrial services report that was filed in this case, which the court has reviewed and will take into consideration. And that pretrial services report shows that the defendant has no real prior criminality that the court should consider in making this determination. However, the court must make this determination based on the offenses that were charged and the nature and circumstances of those offenses. The court would find that there are two offenses which are detainable, which was what the defendant was charged with. Count 3, attempt armed robbery, and count 4, attempt robbery. The court can consider the facts concerning those. The court would note that one of the facts is this was a vast conspiracy amongst several people to commit what the court would consider a violent crime, an armed robbery, and there were steps taken in order to, in furtherance of that attempt. There was also talk of a gun being present, a gun being stolen, and it was based on all those circumstances. The court believes that for the protection of the public and because this defendant would pose a threat to the public as well as other persons because of those actions, the court would find by clear and convincing evidence that this defendant should be detained, that there are no other conditions or combination of conditions that can mitigate that threat to the community and to other persons. So court would detain the defendant, and having found that by clear and convincing evidence, the court would find that the probable cause standard has been met for a preliminary hearing, and the court then would find that the defendant is no longer entitled to a separate preliminary hearing or would need to be indicted because the court in this hearing has found probable cause that the offenses were committed and committed by this defendant. And then Mr. Johnson, first of all, you have a right to appeal this finding. You have to appoint to an attorney.
He had previously,
Did he file an affidavit?
he did, Your Honor, and actually he was previously found indigent, I believe.
Ladies and gentlemen, please rise. Session report is now reconvened.
696, and that's People versus Assistant State's Attorney Josh Jones and Laura Cack and Ms. Gillum. There's been a 4-count amendment.
For the record, those reports and everything in our file were either hand-delivered or were either delivered to the defense in this case, or were made available to the defense, so they had open access to all the information we had and all the information that was provided to the court.
Report on the issue of detention, and then Mr. Nelson, the court evidence. Are you wishing to present any additional evidence?
Not today.
All right. Then Mr. Jones' argument.
And frankly, Your Honor, it's basically the same argument. This defendant, along with many other defendants, were involved in a large conspiracy to commit the offense of armed robbery and robbery. And they did more than just talk about it. They performed a substantial step towards completion of that offense. This defendant was intimately involved in the planning and commission of that offense, along with every other co-defendant. The same language as far as firearms were on the same messages that this defendant had access to as well. It was a plan to steal a gun. It was a plan to pistol whip someone in the course of stealing a gun. This defendant was actively involved in that, and as a result of this defendant's actions, a 16-year-old girl is dead. It's the same argument, Your Honor. This defendant represents the same threat to the public that Gillum Johnson represented, and this court should make the same ruling based on the same facts and evidence that exist for this defendant. There is no substantial difference between the two defendants. I'd ask the court to so find, and I'd ask the court to order the detention of this defendant as well.
Without any specific reference to what Ms. Gillum did, the state has not argued what specifically Ms. Gillum did that would arise to this level of dangerousness. In fact, in regard to dangerousness, there is nothing in her criminal history that would suggest that she is dangerous. In fact, she has absolutely no history, not even a traffic ticket. There is no information in regard to any type of social history or mental health history that would indicate that she's dangerous. And in light of that, Your Honor, the court should not find the state has shown what they need to show by clear and convincing evidence for today's purposes that Ms. Gillum should be detained.
Mr. Jones.
The court's seen the text messages, and the court knows what text messages this defendant had access to, and we can talk about it, but I'm not going to, because the court has already seen it. And the court has seen the text messages that this defendant sent, and that this defendant had access to, and this defendant received. We can talk about them specifically, but there's a time and place for it, and today is not that day.
Muddy River News. Our home, our news.